Thank you. Good evening, ladies and gentlemen. As the President has indicated to you, the Society intends to apply to Scottish ministers to become an approved regulator. And there's a lot of work to be done in relation to that, which I'd like to explain to you. What we've done is we've set up a working party to look at the whole licence provider regulatory scheme. That working party has got members from very wide and differing interests. Everybody will be aware that during the passage of the bill, there were many different views expressed and concerns expressed in relation to various parts of the legislation for licence providers, and therefore the working party has representatives from some of the bigger firms, from medium-sized and small-sized firms, and also there is involvement of the Scottish Law Agents Society. We think it's very important in putting the regulatory scheme together to get these differing points of view into discussion so that we can put together a robust regulatory scheme which will ensure the proper regulation of licence providers. The legislation itself sets out what needs to be in the regulatory scheme, and it's worth just talking about that briefly. The first thing within that is that there are licensing rules. In other words, we're going to have to put together rules and applications which licence providers will complete before we license them. That will also include the test around fitness to own. That's a matter which has clearly caused much discussion during the passage of the bill, and a lot of work is being done in relation to that, including looking at other organisations and professions that have fitness to own type tests. There will be accounting and financial compliance rules, and if you look at the legislation, there is in fact recognition in that the current Law Society regime is a good one, because other regulators are going to be asked to have, at the very least, similar rules to us. There will be practice rules too. As I'll talk about later on, we're currently reviewing the practice rules and looking to consolidate them. Licence providers who will be in competition with solicitors will have to comply with practice rules as well. So there will be, as part of this regulatory scheme, a robust system of regulation which hopefully will ensure that licence providers are getting the same level of regulation and the public are getting the same level of protection in terms of regulation. But moving on, Jamie also mentioned some of the other changes in the Legal Services Bill, which I'd like to make you aware of. The first of these relates to the actual council itself, and Section 92 of the bill will now require the Society's constitution to make provision for actual lay members to sit on the council. The Regulatory Committee will be something new. It is a statutory committee in terms of Section 93 of the legislation, and that committee will have delegated to it by the Council all the regulatory functions that the Society currently has. There's a lot of work there to be done in looking at how that system will work and how it will mesh with the Council and with the Board. The Regulatory Committee will be made up 50% solicitors and 50% non-solicitors, and the regulatory committees, which will work under that committee, have a similar make-up. During the passage of the legislation, there was also concern expressed by the profession about what was going to happen with the Guarantee Fund, particularly as the legislation makes it clear that it will be possible for licence providers who are not regulated by the Society to join the Guarantee Fund. Following discussions over the summer, there were amendments at stage 3 of the legislation which will require other regulators whose providers use the Guarantee Fund to liaise very closely with the Society. And there is now a right for the Society to inspect licence providers who may not be regulated by them if the circumstances allow. Finally, will writers and confirmation agents. The notion of confirmation agents has been around for some time, but will writers and their regulation were introduced to the legislation at a very late stage. The government consulted only in January of this year about the regulation of will writers, and a number of members of the profession had written to us, and we were able to use that evidence to government about concerns in relation to will writers and the need for regulation. What will happen with both will writers and confirmation agents is that there will need to be approving bodies to regulate, and will writers and confirmation agents will need to meet strict standards which these bodies will set, which include standards of entrance and training, a code of conduct, and a discipline system. The one thing that is almost certain is that this part of the bill will be the last to be implemented. Having spoken with government officials last week, it is clear that there is much work and thought still to be put into the regulations which will be needed to make this a reality, and clearly at the moment there are no specific regulators of will writers or confirmation agents, and therefore a lot is going to have to be done to look to see who might come forward as approved bodies to regulate. Thank you.